The next section of our legislative review this year is going to deal with those bills that affected elections and campaigns, and there were quite a few of them this session. The first one is AB 81, and this makes a number of changes to campaign finance law. Ends up being about a page, a 12-point font in a bulleted list. So I'd refer you to the listing there in the book on the key points that this bill does. It changes some of the requirements for the Secretary of State and the county clerk. It requires that early voting includes Sundays and holidays now. It changes the definition of campaign expenses and expenditures. So it obviously does a number of things related to that, as does AB 82, which also makes a number of changes to election law, including stating what order on the ballot people have to be listed if they have the same name, i.e. Ben Graham running against Ben Graham, and one of the Ben Grahams was the incumbent. That Ben Graham has to be noted as the incumbent on the ballot. If a person has been judged by a court in the state or some other method to not be eligible to run for election, that has to be posted at the polling place. This also deals a lot with the expenditure of campaign funds and what they can be used for after the election, etc. It deals with political action committees. It also deals with foreign political contributions to political action committees and cracks down on those fairly significantly.
John, this was the bill that initially moved the judges' place on a ballot up to be a little bit more
Prominent?
sensible in the hierarchy from other officers. But that got pulled out. And the Secretary of State called to apologize to the courts, but that's a story for another time.
Yeah, and I can't remember if it was AB 81 or AB 82. There are so many bills this session, but one of them substantively increased the filing fees for all sorts of offices. It jacked up the Supreme Court filing from what, $300 to like $1,500 or something.
Yeah, that was changed real quick too.
Yeah, that went up pretty quick. AB 132. This bill is a bill that deals with city elections. And the primary gist of it is to allow cities that are currently off cycle, meaning they have their elections not in the same year with a regular election, to come on cycle. And it requires that no current term be shortened by this, but it could potentially shorten the future term of a municipal court judge or other municipal officer to bring them on schedule with the regular election cycle.
John, this caused a number of panic calls. I think the overall effect after a year or two will wear off, but nobody is really going to be prejudiced for long by it, if at all.
AB 337 is yet another campaign bill, and this bill kind of revamps NRS Chapter 294 that deals with how the Secretary of State's office investigates alleged violations of campaign law. And it also requires that if the Secretary of State's office finds the accusation credible and starts an investigation, they have to notify the person who's being investigated. AB 452 is a campaign finance bill that requires several things. First, all campaign finance reports must be filed online with the Secretary of State's office unless a person files an affidavit that indicates filing online is a severe hardship on them. Aggregate contributions and expenses under $100 must now be reported, so the aggregate sum thereof. Reports can be signed under penalty of perjury or an oath under God. If you signed your report to an oath under God, that has the same effect as the penalty of perjury. This was a measure that came from some parties' issue with how that went. The Secretary of State's office obviously has to create the regulations, forms, etc. for this. And judges who have to file a financial disclosure still file that with the Administrative Office of the Courts. That doesn't change.
For those of you who are involved in the election process, be sure and review this, because some of the time frames for filing of this information has been altered as well.
Yes, yes. Assembly Joint Resolution 5, and the star means that you're seeing there on the slide, the star means that it's from last session, and it returned this time. And this would, this is going to be on the ballot in 2012, and it would allow 2/3 of the legislature to call a special session. Currently, the governor is the only officer who has that power, and this would expand that to allow 2/3 of the legislature. We're going to go on to Senate bills now, and this one really deals with the filing of campaign finance reports. And in order to not confuse myself more than anything else, I'm not going to run through the specifics of that, but it makes changes to how far before a primary and how long after a primary or general campaign finance reports have to be filed. I'd encourage you to read this one more than once and kind of get your own idea of it. It's kind of hard to comprehend, in my opinion. And
We were told that the Secretary of State's office would be providing kind of to date myself, a Gilbert's explanation of what this is, and or kind of in a nutshell checklist, so we can sort out just when these filings have to be made.
And it'll probably be a lot easier to understand the gist of this bill once the Secretary of State publishes an actual calendar of this, rather than kind of the generic way statute is written, where 21 days before this, not that. So,
John, I'll talk about the appellate court issue, and it's in our handout here under SJR 14. It did pass the legislature this session. It's essentially similar to the measure that we've been dealing with for the last 10 years. It was defeated in the 2010 election, although it's been revamped some. This will be back before the legislature in 2013, and I can assure you that the courts and the bar are going to be hearing more about this, and hopefully it's something that we can achieve. It would actually be about 2015 before you see it, even if everything falls into place.
the next section of legislation we're going to talk about is the family area. And there were a number of changes made this year in the area of child protection. The first one we're going to hit on is AB 111, and this allows prospective parents, particularly those living out of state, to attend court hearings regarding adoptions telephonically. So again, that's going to be something that court administrators are going to need to be aware of. It also changes the requirement that prospective parents who are going to adopt a child who's in the custody of a welfare agency do not have to live in Nevada 6 months to undertake that adoption. And it also makes some changes regarding sibling visitation for children who are being adopted out of the child welfare system. AB 350 deals with child dependency, and the big issue here is it allows a court in certain circumstances to retain jurisdiction over a child after they turn 18. So that lets the court have a little more time to help that person transition to independent adult living. And it also requires that the Child Welfare Agency, Washoe County, Clark County, or DCFS, to work out a plan and make payments to continue to make some payments to these children.
John, this next one, your SB 57, which was actually sought by a child protective group out of the Attorney General's office, was successfully passed, but with a considerable input from various advocacy groups to make certain that this wasn't an effort to penalize a parent, but it allows some immediate protection of children in the event that they appear that they may have been abducted. Again, it was to cover some areas that where problems had developed, but there were folks that were concerned that it might create some abuses, but it was successfully passed with the Attorney General's folks supporting this.
And if my recollection is correct, I think the standard of proof for such a warrant was increased before the bill finally passed. Senate Bill 167 deals with the release of child welfare reports to the court. And basically this bill allows reports regarding neglect and abuse of a child for whom a guardianship is sought, for those reports to be released to the court, the person who filed the petition, the proposed guardian, and the parent or guardian of the child, and the child if the child is over the age of 14.
With regard, of course, to the military incursions that we find throughout the world, AB 313 dealt with child custody issues for when the family member is in the military. It's kind of interesting because it indicates that there may be some visitation rights to family members of military personnel under certain circumstances, and expedited hearings for child custody and visitation, and again allowing participation by electronic means and by affidavits. Those of you dealing with child custody and family issues really need to review this carefully. Always foremost in the session is something dealing with grandparents' rights, and this very well may shed some light in that area as well.
And of note in this area of custody of children for members of the military, there was a bill, not this one, that created a presumption that the person who was in the military would receive custody, and that didn't pass this session. The next bill we're going to talk about is Senate Bill 128, and that deals with guardians. It requires that a private professional guardian has to have a background check, and that background check has to be shared with the court. It requires that every guardian must file with the court a verified acknowledgement that they know the duties of a guardian and how a guardian is to carry out those duties. And this also clarifies that a court may not remove a guardian solely for the reason that there's a lack of money to pay the guardian.
You know, actually, John, this may expand a little bit the ability of a family member who may not qualified under the old statutory scheme to be a guardian of their loved one. And this, again, is aimed at more at those that were guardians over more than one person. So take a look at that, because this may be a consumer-oriented matter as much as anything.
Okay, the next section we're going to talk about in the 2011 legislative review are bills dealing with fiscal issues in two areas: state finances and county finances. Senate Bill 81, this bill requires that the state controller make payments to vendors electronically in all circumstances unless it would create an undue hardship on the payee. So if, particularly as a judge, you currently receive payments for the state as reimbursement for education or travel, you need to make sure that you're signed up with the state controller's office and AOC accounting to get those payments electronically. If you have any questions, you can go ahead and call AOC accounting to find that out. This also decreases the statute of limitations for a state to pursue debts owed to it from 5 years to 4 years. Senate Bill 505, this one is the bill that cuts state employee pay.
Except those that are constitutionally
except those that are constitutionally exempt, of course, by 2.5%. And it also requires an employee to take 6 furlough days throughout the year, which is the equivalent to a 2.3% decrease. So state employees had an overall decrease of 4.8%. Now this is one of the big ones that affects counties and their finances, and SB 443, and it was also a big topic this session, but it requires counties to pay for 70% of the funding of pre-sentence investigation reports conducted by parole and probation. Now these are the reports that have to be conducted on everybody who's pleads guilty or is convicted of a felony or theoretically a gross misdemeanor in Nevada. It leaves that responsibility with parole and probation, but the counties have to reimburse the state. The counties will be billed by parole and probation for this service on a quarterly basis. The state again picks up the other 30% of the costs, and the state will retain the cost of doing psychosexual evaluations on sex offenders, obviously.
John, I really urge the courts to keep close track of this from a financial standpoint. There was some indication that the counties were going to take this money directly from the court's budget. So far, I don't think that we've seen that happening, but please do keep careful track of this and really some prompt reporting to AOC so we can get an idea if this is really a hit upon our courts, because if it is, there are some things that we maybe need to be talking about.
Yeah. Senate Bill 476, this also kind of follows that trend of pushing expenses from the state down to the county level. The counties have to pay an assessment to the state for the services of youth parole and probation, and this assessment is derived from a formula that is based upon the number of students in public school in the county, so it's fairly convoluted, if I dare say. But again, if you want to understand that formula more accurately, go ahead and read Senate Bill 476. Senate Bill 480 is another one that has an impact on the counties, and in this case, rural counties under 100,000 people. These counties must reimburse the state for the cost of services for the Division of Child and Family Services. And there's also a specific provision in this bill that allows DCFS to bring a court action to compel a county to pay them for services rendered. So again, that's a pretty big hit on the rural counties. The next section of our legislative review this year is health insurance and retirement issues.
Any specialists out there who understand all of this,
You can
let us know.
Feel free to call us and explain this to us. There are a number of bills dealing with the Public Employees Benefits Program. AB 553 indicates that state employees who are hired after January 1 of 2012 will no longer be entitled to receive subsidies for health insurance upon retirement. And these are the subsidies that current folks get between retirement age and Medicare age if there's a difference there. So new hires after January aren't going to have that benefit. AB 556 makes some technical changes on how the state administers its healthcare subsidies. AB 562 changes or sets the current subsidy for retirees, and AB 563 sets the state cost share for current employees, and this is where we've seen the price of health insurance carried by the state employees to go up fairly significantly this time. AB 405 deals with retirement, and this bill creates a legislative interim committee to go ahead and make a study of PERS, particularly dealing with long-term viability, etc.
Just as a side note, it's no secret that there's a number of people that feel that public employees are really abusing the system and creating a lot of the problems. So it's important to watch this study and to take an active part in making sure that the legislators and the public have a fair impression of what the public employees are doing and contributing to the benefits of this state.
Senate Bill 436. Now this is a bill that has a long description for not doing a whole heck of a lot. This transfers the responsibility for making the deposit into PERS for judges and justices' retirement from the executive branch, the Department of Administration, to the court administrator. So basically all it does is it changes who transfers the money to PERS, but it leaves intact the requirement that that money obviously is a general fund obligation of the state. So it just changes who sends the check to PERS to the people who actually have a little more knowledge on what the cost is.
Don't panic.
Yeah, it pretty much does nothing that you're going to see, but in the spirit of full disclosure, we thought we'd include that in this review.